We've all heard some wild stories about homeowners associations, but what happens when a simple request for a password doesn't just get denied, but actually explodes into a full-blown legal battle? This isn't just some angry neighborhood email chain. Nope, this is a case that went all the way to a formal hearing. And believe it or not, it all started with a single login.
And this is where it all ended, with an official decision from the Office of Administrative Hearings. We're talking judges, petitions, the whole deal. So how on earth did a request to see some bank records get this serious? Well, let's back up and see how we got here.
So the whole thing really hit a boiling point on, of all days, Thanksgiving. Yeah, you heard that right. The timing just couldn't have been worse, and it turned what could have been a simple tech issue into an ultimatum with a very, very tight deadline.
Okay, so picture this. It's Thanksgiving, a homeowner, and we're going to call him the petitioner because that's his official title in the case, sits down to check his HOA's bank records online. He types in his login info, hits enter, and access denied. He's locked out, just like that.
Now, according to the official court findings, the homeowner didn't really pause to consider other possibilities. He just jumped to one conclusion. The HOA must have done this on purpose. They blocked him. And based on that one single assumption, he decided it was time to take some serious action. So right there on Thanksgiving Day, he fires off an email to the community manager with a crystal clear ultimatum. You fix this by the end of the business day on Friday, the day after Thanksgiving, or I'm filing a formal petition. The clock was officially ticking.
But here's the thing. This Thanksgiving blow-up didn't just happen out of the blue. To really get what's going on, we have to rewind the clock a little bit and look at the chain of events that led up to this holiday showdown.
All right, let's walk through it. It starts on October 18th. The homeowner asks for online access. The HOA comes back and says, sorry, that kind of read-only access doesn't really exist. But then they actually go the extra mile. On November 16th, they get the bank to create a special password just for him. So far, so good, right? Well, he gets the password, changes it, and then, boom, Thanksgiving Day, he's locked out. He makes good on his threat and files that petition the following Monday, November 28th. And get this, on the very same day, the bank just closes the account entirely. Talk about a twist. So the petition is officially filed, and now we're headed to a formal hearing. Let's break down exactly what the homeowner, the petitioner, was arguing in front of the judge. It really boils down to two completely different stories. On one side, you have the homeowner who's saying the HOA deliberately locked him out and then ignored his deadline, which he says is against the law. And on the other side, you have the HOA saying, whoa, hold on, we gave you this special access as a courtesy. We have no idea why it stopped working, and we certainly didn't do anything to interfere with it.
And here it is, the core of his legal argument, pulled right from the court documents. He wasn't just mad, he was making a very specific legal claim, that the HOA had violated an Arizona state law, the one that guarantees homeowners the right to see an association's records.
And this wasn't just some casual complaint he dashed off. A little footnote in the legal document shows he paid a $500 fee just to file this thing. All of it centered on this one issue of online access. This guy was absolutely serious.
Okay, so that's the homeowner's case. Now let's flip the coin. How did the HOA respond when they were hit with these formal accusations? What was their side of the story? Their defense was really simple and direct. They just flat out denied it. They said we did not interfere with or restrict his access. Their entire position was that whatever happened after they gave him that password was a mystery to them and had nothing to do with any action they took.
So their defense really had four main points. First, they argued, look, we went above and beyond what the law even required by setting up this online access in the first place. Second, we have no earthly idea why his new password stopped working. Third, they doubled down. Nobody here did anything to mess with his access. And finally, their big final point, you know what? This whole thing is moot. The bank closed the account, so the online access he's fighting for literally doesn't even exist anymore.
So you've got two totally conflicting stories. The homeowner's sure he was intentionally locked out. The HOA is saying they're clueless about what happened. So, what did the judge decide? Let's get to the final ruling.
But before we get the verdict, you have to understand this one really crucial legal idea, the burden of proof. See, in a case like this, the person making the accusation, that's our homeowner, has the job of proving their story is true. It's not on the HOA to prove they're innocent, it's on the homeowner to prove they're guilty.
Which brings us to the, well, not the $1 million question, but the $500 question in this case. Did he bring the receipts? Did he have enough evidence to convince the judge that his side of the story was the right one?
And the answer from the judge was a clear no. The petition was denied. And the reasoning was super straightforward. First, the homeowner offered zero proof that the HOA did anything. It was all based on his assumption. Second, everybody agreed that the HOA did give him the login to start with. Third, nobody ever actually figured out why the password failed. And finally, because the bank account was gone, the whole fight was officially declared moot. It didn't matter anymore.
But the judge didn't stop there. He also clarified what the law actually says. The rule is that records have to be reasonably available. It does not say they have to be provided in whatever specific format a homeowner wants. So the HOA offering to give him paper copies? That was totally enough to meet their legal requirement.
And this was the judge's mic drop moment. He basically said that arguing online access is better than paper access might be a great point, but it's a policy argument. In other words, if you want the law to require electronic access, you need to go talk to the lawmakers. A judge's job is just to apply the law as it's currently written.
And with that, the judge put his signature on the final order. The petition was officially denied. Case closed.
But even though this specific case is over, it leaves us with a really fascinating question, especially today. This decision was back in 2017. In a world where pretty much everything we do is digital, what does reasonably available actually mean? Is handing someone a stack of papers still a reasonable substitute for a searchable online portal? That's a question that HOAs and homeowners are definitely still wrestling with.